So welcome to the lawful basis for processing. So without further ado, let's begin. So the lawful basis for processing is one of the 4 compulsory modules for this data collection self-awareness course. Earlier objectives: recognize each lawful basis, understand and explain each lawful basis, understand what rights you have to your data, and data with each lawful basis. So there are 6 lawful bases for processing personal data: consent, contract, legal obligation, vital interest, and public task. And finally, legitimate interest, which is the most flexible of them all. To process data, organizations must simply require one of these legal basis. All companies begin processing personal data. They must determine their legal basis and document it. They must also establish their legal basis and put it in their privacy notice. A legal basis cannot normally be changed at a later period. However, if that purpose has changed, but it is still compatible with the original purpose, they may be able to continue processing data. The majority of legal bases demand that processing be necessary for a certain purpose. The organization won't have a legal basis if it can reasonably achieve the same goal without processing personal data. Different laws give different rights. So important to know that you only need one lawful basis for processing personal data, and what's most important, different lawful bases give you different rights to your data. So before you enter into before you let an organization process your personal data, identify which lawful basis they have, then you'll know what rights you have to your data, because certain ones you won't have the right to erasure, you won't have the right to portability, you won't have the right to access. So it's important to know which lawful basis a company is using to process your personal data. I just went over that, and let's go to consent. All right, the first of the 6 lawful bases is consent. This essentially means that the organization must give explicit permission for an individual must give consent. Essentially when someone gives organization explicit permission to process a personal data for a specified person. Consent is the first of the 6 lawful bases for the lawful basis for processing personal data. Consent must be voluntary. Organizations cannot pre-check boxes that you mustn't check. They do that for many cookies I've seen. Organization must be explicit and precise in the statement of consent. Organization must keep a clear record of consent, who gave consent, when they gave it, and what for. This is so consent cannot be used to justify other actions with data. For example, if I allow processing of my data from July the 1st till October, they cannot process my data afterwards for a different reason. Even though I gave consent, I only give consent for that date. Another reason, like if I give consent for a variety of dates, but I only allow them to process my data so I can find out how to track how fast I swim. I would not like them to. They cannot collect the data I have. They cannot process the data I have for the specific purpose of tracking how fast I swim and use it to see how fast I run, for example. So consent is quite difficult to acquire, and it's one of the more difficult ones to acquire for organizations. So they tend to not to use it. They will tend to use legitimate interest more than anything else, but that's quite pliable. So your rights in relation to consent. So before going any further, there's a whole module on rights itself, but I'll quickly go over them here right now. So the right to object means that you can object for a company to process your personal data. This means they have to stop processing data. The right to withdraw consent at any time means that that means if you give consent, you have the right to withdraw it. And withdrawing consent should be as easy as accepting consent. So if I tick a box saying accept consent, to withdraw it, I just have to tick another box saying I accept consent. There should not be a long drawn out process where I have to call someone and they have to fill out forms and all that to withdraw consent. The right to be informed means you have the right to know what's going on with your data, what's happening with your data. There are many things that you need to know or what's happening with your data when an organization processes. I won't go into essentially you have the right to be informed. Right of access means that you have access, so you can receive a personal copy of your data. Amazon does this, so if you want to look at what data Amazon has on you, you can do this. Most organizations will have to do this. The right to rectification means that if there is any incorrect data, that you have the right to correct it. You have the right to tell them to correct your data. The right to restrict processing essentially means that you can stop an organization processing your data for a certain period of time for a certain reason. For example, it's not correct, or you don't believe that they have a legitimate reason for legitimate purpose for processing data. The right to data portability, that means if Amazon has all my data, I can switch it to Google. I can ask them to send it to Google, or if Amazon has all my data, I can ask them to send it to me quickly. And the right to erasure means just deletion of data. So again, so if you provide an organization with the right to process personal data, the personal data based on consent, you do not have the right to object, but you do have the right to withdraw consent at any time. And withdrawing consent should be accepting consent. You have the right to be informed, the right to access, the right to verification, the right to restrict processing, the right to do data quality, and the right to erasure. Contract. A contract is the second of a legal basis for processing personal data. In legal terms, a contract is a binding promise by one party to fill an obligation to another party in return for consideration. A basic binding contract must comprise of 4 key elements: offer, acceptance, consideration, and intent to create legal relations. Organizations can only use a contractual legal basis to process an individual's personal data if it's to fulfill a contractual obligation to them, or if the individual specifically requested it before signing a contract. Organizations can only process their personal data if necessary. A contract is legally binding and does not necessarily have to be written. It can be oral as well. And organizations must document a contractual basis and be able to justify them. This is very important. It can be oral as well. So if you orally give your consent for organizations to process your data, say if you record a statement saying, I give consent for organization to use my data for so and so, that's considered consent, and it does not be written down. But if you give orally and witnesses as well, that could also be troublesome. So usually organizations won't use oral consent, but if they do, they will normally follow with documentation. Necessary is a term that often arises when discussing lawful basis. It essentially means that they can achieve if they can achieve their objectives with less invasive method in relation to individual personal data, this lawful basis will not apply. So your rights in relation to contractual obligation. If you provide data based on contractual legal basis, you do not have the right to object, the right not to be subject to decisions based primarily on automated processing. So I didn't mention this one before. This means like if an organization collects data, they use the AI to make decisions about your data. So they can use an AI to, for example, collect your credit score, and after that they'll just say you apply for credit score, and they immediately just decline it. You don't have the right to data portability, right to erasure, right to be informed. You do have the right to right to data portability, the right to erasure, right to be informed, right to access, the right to verification, and the right to restrict processing. Now, legal obligation is the third of the 6 lawful bases for personal data. This only applies when processing personal data required for organizations to comply with the law. Comply with the law. If organization wants to use lawful basis for processing personal data, organization must document the legal basis to justify it. The organization must be able to identify the legal obligation in the law, and the processing must be necessary. Contractual law basis is not the same as a legal obligation. So you cannot contract someone to do something illegal, essentially. That's what I mean. That's the easiest way to describe the difference. A contract is when you contract someone to do something for you within the confines of the law, and legal obligations when the law requires you to do something. So interesting about this one. Remember, if a legal obligation could be, remember this one, as a legal obligation could be something you disagree with. In some countries, freedom of speech is limited, so organization could process your personal data, but as a legal obligation to find out who's watching certain content, or who's following certain individuals who they disagree with, or parties they disagree with, or who's watching homosexual content, or content that they disagree with. Remember, there are times in history when reading certain books will get you sent to prison, or for certain sexualities or certain sexual orientations will get you thrown into prison. So remember, this is an important one. It's powerful for governments to use and organizations to use, and they can predict what you watch and what you do because they're collecting mass amounts of data. For organizations processing your data based on legal obligations, you do not have the right to erasure, the right to data portability, the right to object. So you do have the right to be informed, the right to access, the right to verification, the right to restrict processing. This is the one where you have the least rights, so be careful. It will not apply unless you're in serious trouble, but the government has a lot of power in this case. This is legal obligation. Now, vital interest. Vital interest is the 4th of the 6 lawful basis for processing personal data. You can only use vital interest as a lawful basis if it's to protect someone's life. This means that it typically only applies in life or death circumstances. If an organization is going to use this lawful basis for processing personal data, processing must be necessary to save someone's life. If an organization can reasonably save someone's life in a different, less invasive way in relation to your data, they must do so. And if the individual is capable physically, legally, and mentally of giving consent, you cannot process their data if they refuse. Organizations must document the vital interest and be able to justify it. So if an individual refuses to let you process your data to save their life, you still cannot process it. If you do, and you're liable to fine by GDPR, even if you save someone's life. So as an individual, this is very important to know, not just for organization, but as an individual. Also, remember, reasonable and less invasive is not specified, and this will be up to your discretion. From the court cases I've seen, which are very few in this case, it's very hard for someone to prosecute you under this vital interest one, because most of the time the court will side with you just because of decency. It seems like it, even if they've clearly like defined this, clearly broken this broken this statement, like process, broken the point of the statement, like processing personal data to save books. But still, you should be aware of that. So your rights in relation to vital interest. No one has to processing personal data based on vital interest. You do not have the right to portability, the right to object, though you do have the right to be informed, the right to access, the right of erasure, the right to ratification, the right to restrict processing. Okay, public task is the fifth or the sixth lawful basis of personal data. Public task is a legal basis and can only be applied if you're covering a legal public function or performing a specified work in the public's interest set out by UK law. So it has to be set out by UK law. That's an important thing to remember, that what function they're carrying out is set out by law. There is a precedent of this by law. If an organization is going to use public interest as a lawful basis of processing personal data, processing must be necessary. This though normally applies to public bodies rather than organizations, but if organizations do take on these duties in public interest, they can all do so if they have a clear and specific legal basis. The organization's public authority must document, organization or public authority must document this legal basis and prepare to justify it when processing personal data. This base means that public task as the interest is set out by law. But again, this is right exploitation. You could say, could you process my credit history or my purchases to make sure that it was me who bought these things, or make sure that the individual bought these things. And the law can be very vague sometimes. So it hasn't been very exploited yet, but again, the GDPR has only existed for 4 years, and I'm sure more cases will come. So your rights in relation to public tasks. You have the right to erasure, you have the right to data portability, but you do not have the right to object. You do not have the right to be informed. You do not. You do have. You do not have the right to erasure. You do not have the right to data portability, but you do have the right to object. You do have the right to be informed. You do have the right to access and the right to ratification, as well as the right to restrict processing. Finally, legitimate interest. Legitimate interest is 6 of the 6 lawful basis of personal data, and by far the most pliable and controversial. The legitimate interest can be an organization or individual's own interest, third-party interest. They can be commercial interests, individual interests, or broader societal benefits. Essentially, this means this can be any interest. More on the effectiveness of the GDPR, but organizations should process personal data in a way which is consistent with what a person would reasonably expect, and has least negative effects on the person, and does not harm the person when using this legal basis for processing personal data. So, interesting note: if you go on the government website and type in what the government defines as a commercial interest, it defines it as a profitable interest. A profitable interest, like somebody's carrying activities with underlying expectation to make a profit. So, any profitable activity can be used to process your personal data. So, without asking permission, consent, or anything else, they will process your data, the date of birth, your personal data, what you watch, what you read. They can do that based on legitimate interest, as long as they're trying to make a profit. This is the one that I most disagree with, and this is the one that'll be more in the effectiveness of GDPR, and this is the one that most organizations use. When I said consent is quite hard to get, this is the one they'll use. It should be noted that organizations have been stretching the pliability of this quite a bit, and I hope there's some rectification to this. If you look at Facebook's statement, they say we process your data into legitimate interest processes to make a profit. So yeah. So if organizations are processing your personal data based on a lawful basis for legitimate interest, you do not have the right to dataability, but you have the rest of the rights, essentially the right to erasure, the right to object, the right to be informed, the right to access, the right to verification, and the right to restrict processing. But if a company uses legitimate interest if the company uses a legitimate interest for direct marketing, the individual's right to object is absolute and must be respected. So that means if you write to object personal data for people if the direct marketing is sending directly to the email, they must do that. If that's the one, if that's the one the law is very strict and clear on. So if they do that and you write a check and an organization disagrees with you, that's fine. Taking to court, you will most likely win. Okay. Quite interesting thing is that if you register as a new user in the UK on Amazon, you have the option to opt out of direct marketing. But if you sign in, if you sign the US has no such option, and you can see that many companies. And another interesting thing is like if you compare the privacy notice where all information on the right to be informed is in different companies, you'll see that lawful basis is only a EU and UK thing. And if you go to the American website or the Thai website, they don't have the lawful basis for processing your data. Okay, that's it. Thank you very much for listening to this module, and I hope to see you in the next module.